So now a lot of people ask, what is an injunction? So an injunction has been broken down in this story. So gear up and be ready to learn. So we'll look at what is an injunction as well as the types of injunctions. So now the first question is, what is an injunction? So now an injunction is a court order directing a person to stop doing that which they should not do. So it directs a person or an entity or a company to stop doing that which they should not do. So it means that that which they should not do, it's something which is unlawful, right? So just to sum you up, look at the case of Madison Square Garden v Carnival. It will talk about an injunction which was granted, and you get to understand more on the topic of injunctions. So the second question is, what are the types of injunctions? Right. So the first type of injunctions is interim or temporal injunctions. So interim or temporary injunctions, these are injunctions that are granted urgently to prevent immediate harm before the court hears the full case. So there are situations whereby a case, before it is heard, you'll find that there is this unlawful act which, if it is occasioned, it will cause irreparable harm to the plaintiff. So the court will issue an interim injunction or temporary injunction that will prevent the defendant, or let me say a party, from doing that which they should not do, to prevent the plaintiff from occasioning an irreparable harm. So this is done so that before the court can hear the full case, because once the court hears the full case, now they can provide these other injunctions which we're ahead to look at. So the second type of injunction is a interlocutory injunction. So what is an interlocutory injunction? So interlocutory injunctions operate during a lawsuit's pendency to maintain the status quo until judgment. So interlocutory injunctions, these ones, they are granted during a lawsuit. So you now look at the fact that, whereby, let's say, a trial has already started, the lawsuit has already been issued, and then things are now at court level, and then here comes the, let me say, the claimant saying that, okay, now there's this certain unlawful act that if the defendant acts, then there shall be an irreparable harm which shall be occasioned. So now the court now will issue an interlocutory injunctions. So simply, this is more like when you are interlocuting, let me say, a defendant, or maybe let me say a certain lawsuit, you use this injunction to help you maintain the status quo. Let's say, for example, you want to go to, let me say, a claimant has got this feeling that or maybe let me say, they should be sure, sorry, not a feeling, but they should be sure that the defendant has got the proof in their house, right? The claimant, the defendant has got the proof in their house. So now, upon issuing proof that they know really that the defendant has got a certain evidence in their house, the court can issue an interlocutory injunction that will restrain the defendant from doing anything that will change the situation at that particular time, and that is what we call status quo, meaning that anything that is at that particular time should remain the same. So it should not be changed until a judgment, until they see that, okay, this person indeed has got that evidence in their house, or maybe let me say this person doesn't have an evidence in their house. And then the other type of injunction is a permanent injunction. So a permanent injunction now is issued after final judgment to restrain a wrongful act permanently. So now this is where now the courts have now like finalized the final judgment, and then they have now come to a conclusion. Now they are giving a final and permanent injunction that will restrain or stop a certain party from doing that which they should not do. The other type of injunction now is mandatory injunction. So what is a mandatory injunction? Mandatory injunction orders a party to do a specific act. Let's say ordering a company to put down a building built in breach of a contract. So let's say, for example, we contracted to do something, right? Let me say I contracted with, or let me say A and B contracted to build a house. So A contracted that they should build the house for B. And then once A builds that house, B refuses to pay. So the courts can issue a mandatory injunction to put down that house for which A built for B, since they did not want to issue to make, let me say, B unjustly enriched, since it will cause now another tort, which is quantum merit. Yeah, so you will look at that when you're looking at we'll be looking at what's this when you're looking at rescission. Yeah, rescission, which is also a type of equitable remedy. So now the other type of injunction is prohibitory injunctions. So prohibitory injunctions, these are just restraints or restrains a party from doing a particular act. So they stop a party from doing a particular act which they ought not to do. Yeah. So the other type of injunction, and the last and final one, is quit-timate cure-timate injunction. So cure-timate injunction, this is just granted to prevent an anticipated or threatened harm before it occurs. So like, let's say for example, a claimant says to the court that, okay, I fear that the defendant might do this and this. So you have anticipated that threat or harm, and then the court will issue a quit-timate injunction to prevent that harm from being occasioned. So now there may be a question to say that, when can these injunctions be granted? This remedy of injunction, when can it be granted? So now this remedy of injunction can be granted in three scenarios, right? So now it is usually granted to prevent ongoing or imminent harm. So there are few circumstances when it's granted. So first, when monetary damages would be inadequate to address the harm. And then secondly, when there is a serious issue to be tried. And then third, when the balance of convenience tips in favor of the person seeking it. So now, just on this, I want us to go back to the first part here, this one. So you look at when monetary injunctions would be inadequate to address the harm. So this is the other reason why equitable remedies come in, because equitable remedies come in when monetary injunctions cannot be adequate. And then look at the second one, it's when there is a serious issue to be tried. So something which, and a harm which is irreparable, something which cannot be repaired, right? It's something which is considered to be a serious issue. So that is an issue whereby a court can issue an injunction to prevent from being occasioned by the plaintiff. Yeah. So you're now looking at also the balance of convenience, so in favor of the person seeking it. So if you look at it really that the claimant might suffer an irreparable harm, then injunctions can be granted. So also courts look at whether the injunction would cause unjust or harm to the other party. So it's a balancing act. So when you look at the courts, they weigh the interest and the urgency and the fairness of the situation, and they can grant it as an interim measure or as a final remedy depending on the case. Yes. So thank you very much for your time. Hope this was helpful. I'll see you back soon for another embracing and vibrant topic. Thank you very much.